I'm very honored to be here. I must admit this is my first tea party in El Dorado County that I've been to, which is a shame because I live right across the freeway. Well, when I try to impress people, I tell them I live in El Dorado Hills. Actually, I live in Cameron Park. Actually, when I'm trying to impress people, I tell them I live in Cameron Park. I actually live in Rescue. Let me also start with a disclaimer. I have not read the entire law, which means I'm qualified for Congress. But my wife has read the entire law. My wife is also an attorney who is helping in the legal fight against Obamacare and all of its various unconstitutional provisions. Let me start out by admitting another embarrassing fact, and that is I'm a lawyer. But I sue the government for a living, and which is the best job in the world. I would do it for free if I had to. And in fact, I sort of do, because I work for a nonprofit organization that represents clients free of charge in order to support constitutional protections in defense of individual liberty. And we are, I'm proud to say, the most active organization in the country in opposing Obamacare. In the past, what has it been now, 2 years, we filed, aside from our own lawsuit challenging Obamacare, we filed 10 briefs in courts from Virginia to Arizona to Florida to Michigan to Washington, D.C., various lawsuits challenging Obamacare. Now, of course, as you know, the biggest issue that was really at the heart of all the controversy is the individual mandate. That's a provision of the law that forces you to buy health insurance from a government-approved form of health insurance from a private company, whether you want to or not. Now, the reason for the individual mandate was in order to counteract the effects of the guaranteed coverage provision of the law. That's the portion of the law that forces insurance companies to insure you whether they want to or not. And I think it must be emphasized that that provision of the law is an injustice and unconstitutional and wrong. It is wrong to force businesses to do business with people that they don't want to do when they have done the assessment and figured out that it's not worth it to them. Forcing insurance companies to insure sick people makes no more fiscal sense than forcing fire insurance companies to insure homes that are already on fire. And yet the attitude has been, both on the left and the right, that the guaranteed issue provision of this law is somehow morally praiseworthy or legitimate or worthy of being retained. It is not. But that provision also imposes great costs on insurance companies, and so in exchange for that, the Obama administration worked out this deal where they would force everybody to buy insurance, whether they needed it or not, in order to subsidize the insurance companies for the costs imposed on them by this law. And of course, then the question comes, where in the Constitution does the federal government derive the power to force you to buy health insurance? I'm sure you all have your constitutions with you, so if you'll take those out. Actually, that's always a dangerous joke in a crowd like this. Because you probably all have
one. I just don't have it right
tattooed
now.
on your arm. I always carry my handy Constitution iPhone app. It was very helpful in court. You just whip that out when the judge asks you a question. Of course, the federal government has no constitutional authority to provide health care or take care of people's insurance needs or tuck them into bed at night. Right. The Constitution of the United States gives the federal government a limited set of enumerated powers. Article 1, Section 1 of the Constitution says, all legislative powers, note the plural, not just all legislative power, but all legislative powers herein granted shall be vested in a Congress of the United States. Not all power, but only those powers herein granted. And then they're listed specifically in Article 1, Section 8, and in a few other places in the Constitution. And those powers include things like laying and collecting taxes, establishing post roads, maintaining an army, and so forth. And, of course, to regulate commerce among the several states and with foreign nations and with the Indians tribes. Actually, I misput that. It's to regulate commerce with foreign nations and among the several states and with the Indian tribes. Which is funny phrasing if, like most modern law professors, you think that that is the fountain of all federal power. Indeed, you would think if the federal government can force people to buy things under the commerce power, can we force foreign nations to buy things under the commerce power in order to eliminate the trade deficit? Right? The argument that the administration put forward was buying insurance has effects on the nation's economy. If you don't buy insurance, then there's going to be consequences economically. Therefore, it's a regulation of commerce for us to force you to buy insurance. Now, of course, the first problem with that is that absolutely everything and nothing affects the nation's commerce if you go far enough, right? It's the old butterfly in Central Park flaps its wings and there's a hurricane in China argument, right? Eventually your consequences, the little old lady swallowed the fly in order to catch the spider in order to affect national commerce. That kind of argument gets the federal government absolute unlimited authority, and if that is the proper way to interpret the Commerce Clause, why did the founders bother writing the rest of the Constitution? Seriously. Article 1, Section 8 says things like, to coin money. Coining money affects the economy, right? If the Commerce Clause allows the federal government all power over everything that has any kind of an effect on the nation's economy, then there's no point to also say that they can coin money, right? An old legal rule says you should never interpret a written text in such a way as to render any of its provisions void or unnecessary. But the Commerce Clause argument the administration put forward would have rendered the entire Constitution of the United States unnecessary and redundant of the Commerce Clause that they said gave the federal government absolute power. And of course, the term regulate doesn't mean to force. It means to regulate means to set the boundaries over conduct that people voluntarily engage in. And the word commerce doesn't refer to the failure to do something. The failure to do something is no more commerce than it is red or Tuesday, right? It's nothing. It doesn't. Not buying something isn't something, so you can't describe it as anything. So it makes no sense to call it commerce. But of course, then their fallback argument, the last refuge of a constitutional scoundrel, was the necessary and proper clause. This is the clause in Article 1, Section 8 that says that the federal government can make all laws necessary and proper for carrying into effect the enumerated powers. Interestingly, there are very few cases defining what necessary and proper really means. The most famous one is the 1819 case of McCulloch versus Maryland, in which the Supreme Court upheld the constitutionality of the National Bank. And people have interpreted that case as like the final word on what necessary and proper means, and as standing for the proposition that the federal government can do whatever Congress thinks is convenient. But the clause doesn't say convenient. The clause says necessary and proper, which means not everything that's necessary is proper, and not everything that's proper is necessary. So we argued in front of the Supreme Court that not only is this not a regulation of commerce, but it's not necessary and proper. For one thing, it would transform the Constitution from a system of limited enumerated powers into a general power to do whatever Congress thought was a good idea. And that cannot be proper under a Constitution that was written to limit federal authority by, let us remember, a group of patriots who only, 11 years earlier, had written a Declaration of Independence in which they castigated the British monarchy for asserting authority to, quote, control us in all cases whatsoever. Right? One of the things the Founding Fathers really hated about what the British were doing to them before the Revolution was the Declaratory Act. The Declaratory Act was a parliamentary enactment that said that the Parliament had the authority to bind the colonies in all cases whatsoever. The Founding Fathers hated that so much that they specified it in the Declaration of Independence as one of the reasons for breaking with the British monarchy. What does it say about the current generation that we now have a presidential administration whose interpretation of the Commerce Clause is tantamount to a power to dictate to us in all cases whatsoever? Because everything affects commerce. And if they can force you to do this, what can they not force you to do? And so that's where we came up with the broccoli argument. If they can force you to buy insurance, why can they not force you to buy broccoli? To which one of my favorite law professors, Erwin Chemerinsky, the dean at a law school in Southern California who can always be relied on to take the most extreme liberal position on absolutely anything, admitted on camera, yeah, they could force you to buy broccoli. So I went to the Supreme Court to hear the oral arguments in March stood in line for 10 hours at a time. You have to stay in the line from about midnight till 10 in the morning when the argument starts. And that's if you're a lawyer. If you're a layman. So I stood in those lines so you didn't have to see this oral argument. And boy, that was great. That was a lot of fun. You're welcome. Hey, I'd do it again. Wait a minute. I've won cases in front of the Ninth Circuit Court of Appeals, and you're applauding me for standing in line? Anyway, so I went to the oral argument, and it was great, very interesting. And you can listen to the oral arguments still on the internet. You can find them really easily if you didn't already listen to them. And I'd recommend doing so. Skip the first day, it's very boring. But the second day's oral argument, absolutely fantastic. And the third day's, I thought, was even more interesting than that. And then, of course, we got the decision in late June. Now, here's where I would like to try to explain something that the media and even some of the legal minds on our side of the spectrum have got wrong. I'm holding here the decision in the cases. There's several different opinions. And a lot of people say, well, the Supreme Court upheld the law as a tax. And that is not what happened in the decision. What happened in the decision is that 4 justices ruled, the conservative justices said the entire thing is unconstitutional. Then Chief Justice Roberts wrote a separate opinion, which was joined in part by 4 liberal justices. Now, an opinion that receives the support of 5 justices is controlling precedent. That's the opinion of the court. Okay? Now, Roberts said this mandate is unconstitutional under the Commerce Clause. Then he said, but the penalty provision that imposes a tax on you, a financial penalty assessed by the IRS for not having insurance, that is a constitutional tax. And the only reason I'm making that decision is because the tax is not so severe as to actually compel behavior, and if it did, I would say it was unconstitutional. And because I otherwise would rule this law unconstitutional under the Commerce Clause. And the 4 liberal justices signed on to that opinion. What that means is the individual mandate, the order, the compulsion part of the law that says you must buy insurance, that part was found to be unconstitutional by 5 justices, the 4 conservatives and Chief Justice Roberts. The assessment of a penalty for people who don't have insurance was found to be constitutional as a tax by 5 justices, Chief Justice Roberts and the 4 liberals, only on the condition that the penalty not be so severe as to compel behavior. Now, you're all thinking that that is the distinction that only a lawyer can love, right? Okay, so they can't force me to do something, but they can tax me for not doing it. I saw this poster that somebody made that said that it's a dialogue between you and a cashier at the grocery store, and the cashier and you say to the cashier, "No thanks, I don't want a pack of gum." And the cashier says, "Okay, that'll be $3 tax for not buying gum." Believe me, I get that. But the reason that this distinction is important, there's a couple reasons. The first one is because the Commerce Clause power is extremely dangerous. It has been the source of federal authority that has been expanded so that the federal government today dictates everything from the thickness of ketchup to the angles of the chairs that you can sit at in your workplace. That has been the fountain of federal authority since Franklin Roosevelt's day. And so a Supreme Court opinion that puts hard and fast limits on the commerce power is extremely important. It's very important, it's crucial for people on our side of this debate not to minimize what happened in this case. This case found the mandate unconstitutional under the commerce power. It drew a line and said, you cannot go beyond that line. That really is a significant victory, and it changed the situation so that we no longer can say, as liberal law professors have been saying, that the commerce power is really just a national problems power, that the federal government can do whatever affects the nation. That is not the case. Now, of course, a lot of judges and lawyers, and even the Ninth Circuit Court of Appeals on Monday issued an opinion saying, we don't know what this decision really means, because we don't know how much of Chief Justice Roberts' opinion really is binding on lower courts, because he wrote this opinion that was joined by 4 liberals in part, and so we don't know whether this whole thing about Commerce Clause doesn't allow this, and all, we don't know how much of that is binding law. The Ninth Circuit just said that on Monday. So what's crucial now is to take a step and have another court say, what part of the law, what part of this decision is binding on lower courts and why? Now, what about this tax? I'll just say this about the tax. The Constitution requires that all bills for raising revenue originate in the House of Representatives. This bill did not originate in the House of Representatives. What happened was that the Senate took a bill which, of all things, provided tax credits for veterans to buy homes, and struck out all of it and replaced it with Obamacare. That's what the Senate did, in order to claim that this bill originated in the House of Representatives, and then they deemed it to be passed. Now, the Supreme Court of the United States has never decided a case in which it has invalidated something for failing to satisfy the Origination Clause, but that's because this question has rarely come up before the U.S. Supreme Court. So I'd like you to keep that in mind as this debate goes forward. Now, I'd also want to talk about some of the other challenges to Obamacare that still live. The big one is the Independent Payment Advisory Board. This is an independent agency. It's one of these, I think it's that one. This is a group of experts appointed by the president that's going to set Medicaid reimbursement rates. I'm sorry, Medicare reimbursement rates. Their recommendations, that's what the statute calls them, recommendations, automatically become law with no congressional, presidential, or judicial oversight. They are immune from judicial review. The president cannot alter them, and Congress can only stop their recommendations from going into effect as law if it passes a joint resolution that's introduced after January 3rd and before February 1st, 2017, and receives the votes of 3/5 of all elected representatives. Otherwise, IPAB is purportedly unrepealable. The statute says it is not within Congress's authority to repeal the statute. Now, that part of the law has been challenged in a lawsuit that has been brought by the Goldwater Institute in Phoenix, Arizona, where my wife works. And they're arguing that that agency is a violation of the non-delegation doctrine, which is the rule of law that says Congress can't just say to somebody, okay, you're Congress now, we're going home, bye. Right? They're not allowed to do that. They're not allowed to give away their authority in that way. And this lawsuit says that that's what's going on here. That case is waiting in the trial court for a decision, and it's been a while, so who knows what's going to happen. Finally, if you want to know what can be done politically, the big important thing to do at this point to combat this law is to stop the states from creating exchanges. Have you heard about these exchanges? These are the state-created fake markets where you can fakely buy fake contracts for insurance. Unfortunately, a lot of Republicans have been suckered into the idea that these exchanges are a good idea. The reason why is because they think that it keeps state autonomy for the state to create an exchange. Of course, the law says that the state doesn't create an exchange, that the federal government's going to do it for them. But a lot of Republican governors are under the illusion that these state exchanges preserve state autonomy and are good for the taxpayer. And they're not. They're a terrible idea. They are not, in fact, an exchange. They're worse than a shopping mall at an airport where you have two choices, so the prices are through the roof, right? The government says what kind of insurance can be sold in these exchanges. It's not a market, it's an illusion. And if the states don't set up these exchanges, the federal government does not have the wherewithal to set up exchanges in all the states at this point. So what needs to be done as far as elected officials is concerned is they need to make sure not to set up these exchanges. California has set aside money for creating exchanges, but has not yet taken the steps to do so. The American Legislative Exchange Council in Washington, D.C. is currently working on model legislation to recommend to conservative elected officials how to prevent these exchanges from coming into place. But if you want to point on what you can call your representative about, that's it. If the states start implementing these exchanges, it really will be impossible to do anything about Obamacare. So, as far as what our next step is at Pacific Legal Foundation, I'm not at liberty to say just yet. But I will say that within the month, you will hear our announcement about what our next step is in challenging Obamacare. But this case is not over. We did not lose, and the next step has yet to be taken. Don't let the other side fool you into losing your momentum in opposing Obamacare. This is an unpopular law, and deservedly so. So please read the opinion and be confident that we won 2/3 of our arguments, and that third argument isn't over yet. I'd be happy to answer any questions that you might have.